May it please the Court, my name is O'Brien, initial L, solicitor in the employ of legal aid, appearing on behalf of the defendant, Mr. Marshall Ike. The defence admits that Section 133 of the Evidence Act applies to exclude police interviews tendered by the Crown on grounds that its reception and evidence at trial would be unfair. This submission rests on two main issues. Firstly, my client's rights, as legislated by the Police Powers and Responsibilities Act, were obstructed. Secondly, procedures for interviewing my client, specifically as an Indigenous juvenile, were not followed. Following the case of Lee, the defence applies to the Court to ask Your Honour to exercise your discretion to exclude evidence relied on by the Crown. The police failed to adhere to their legal obligations, and it is the defence's case that my client's admissions of guilt were obtained through deprivation of natural justice. He was not given the ability to understand what was happening, nor was he given the opportunity to be heard. Consequently, this has resulted in an unreliable confession that is highly prejudicial to his prospects of a fair trial. Upon my client's arrest and subsequent questioning in the police vehicle, police made no effort to gauge his level of understanding, contrary to Section 25, subsection 1 of the Police Powers Responsibilities Regulation. It is clear, as the interview progressed, that my client had a limited awareness for the situation he was in and what he was admitting to. Your Honour, the pre-trial decision of Adam Mick sets precedent that failure of a police officer to delay questioning to allow a defendant to contact a friend, to contact family members, friend, or lawyer gives rise to the unfairness discretion. Police disregarded my client's rights contemplated by Section 418, subsection 1, and did not give him the opportunity to contact a family member or lawyer. This is a particularly salient issue in this case, given the defendant's youth, cultural background, and education. Mr. Ike was at no time informed of his right to silence upon his arrest and subsequent questioning in the police vehicle. Section 431, subsection 1, requires that a police officer caution a relevant person before questioning, specifically their right to silence, as per Section 26(1), subsection 1, Your Honour, of the regulation. Your Honour, my client was deprived of his fundamental civil liberty to exercise a choice as to speak or remain silent. It is also very likely, given the defendant's youth and cultural background, that he was not aware that he had this right. Police drove around the neighbourhood and pointed at 84 properties and asked my client whether he had broken into them, at which he responded yes multiple times. I am instructed that my client answered yes to be respectful rather than because he adopted and understood the questions being asked. Such gratuitous concurrence is recognised in the Supreme Court of Queensland's Equal Treatment Bench Book as the tendency of a speaker to agree with the proposition put to him or her, regardless of whether the speaker truly agrees with it or understands the proposition. Your Honour, my client at no point explained to police officers what happened in his own words, nor was he aware that his admissions were evidence that could be used against him. Chief Justice Gibbs held in Cleland and the Queen that a confession will not be admitted unless it was made voluntarily, that is, in the exercise of a choice as to speak or remain silent. My client's confession was not made voluntarily, and it is highly prejudicial to his prospects of a fair trial. The probative value of this confession is diminished given that my client did not understand or adopt the questions being asked. It is not probative because it is highly unreliable. It is my respectful submission that this evidence should be dismissed. Your Honour, I would now like to draw your attention to the subsequent interview conducted at the police station. My client, at 14 years of age, is a child as per Section Schedule 4 of the Youth Justices Act. At this stage, it would have been reasonable for officers to suspect that my client was a child of Torres Strait Islanders descent. However, police did not inform a representative of legal aid that my client was in custody as per Section 420, subsection 2 of the Police Powers Responsibilities Act. Furthermore, Section 421, subsection 2 provides that a police officer must not question the child unless the child has been allowed to speak to a support person chosen by the child. My client did not choose his support person. The police gave him no opportunity to contact a family member or lawyer. A white middle-aged woman was chosen by police whom my client had no cultural ties or association. At no point did she explain to him the charges against him or of his right to silence. The only input offered was, well, just answer the questions, okay? Not only was my client intimidated, this statement highlights a social worker's ignorance to the legal issues confronted by Indigenous Australians whilst in custody. It is common knowledge that people, when confronted by alien institutions and authority figures, may adopt a strategy of always agreeing. The pressure of interrogation at a police station deprived my client of any ability to exercise a choice as to speak or remain silent. The failure of police to afford my client the opportunity to choose a support person and to deny legal representation has resulted in his limited appreciation for what occurred. I would now like to address the admissibility of the alleged admissions of guilt and the recorded interview. Your Honour, the majority stated in Swaffield that the purpose of the discretion to exclude evidence is the protection of the rights and privileges of the accused. In Foster, the High Court found that any significant infringement of a defendant's rights would constitute unfairness. The police obtained my client's confession by ignoring his fundamental statutory rights, and I asked the court to balance the probative value of this confession against the prejudicial detriment to my client in a fair trial. My client cannot be held accountable for any admissions made whilst in police custody, and it is my respectful submission that all evidence obtained in conflict to legislation should be inadmissible. The police cannot establish the identification of the offender responsible for the 85 offences, and all charges that have arisen from my client's admission should be dismissed as Your Honour pleases.